Good afternoon. It's nice to meet everyone after having spoken with you on the phone. Again, Jody Miller, and I'll be your mediator today, as you know. And I'd like to talk a little bit about, or check in with you about some of the ways that the mediation will unfold today. First, I'd like to thank you for, you've all read the confidentiality and agreement to mediate form and getting that back to me, so that's taken care of. I know I've spoken with all of you about my role here today, but just once again, my role will be to facilitate the conversation that you all would like to have in any way that you would like to have it. Sometimes when that happens, people get clear about what they'd like to do, what their next steps are, what something means to them. You're able to certainly come to any decisions that you think would be helpful here today. Sometimes people understand the perspective of the other, new information comes out. So there are lots of possibilities about the ways that this conversation can unfold today. And my role is to help that discussion happen in a way that's the most useful to you. One of the things I wanted to check in with you about is how long you would like to spend today with this mediation session. I know I spoke with each of you about that on the phone before we came today, but I thought it might be useful just to, again, check in with you to see what your time frame is, how long you'd like this conversation to go. I've set aside a large chunk of time, a number of hours, but do either of you have any constraints on your time, or what would you like to see?
We are here to try and reach some resolution of this matter, so we're willing to give it whatever time is required here. So
okay.
We're open-ended on that regard.
Well, we are here for the same purpose as well. We don't think it should be just an indefinite amount of time. 5 hours is we think it's a little on the outside.
I would hope that we need far less than that.
Yeah. So we were thinking, let's give it a couple of hours and see where we're at. If it's not being productive, then we'll revisit if we need to go further or not. But that's what we were suggesting.
Okay, so in terms of the amount of time, you have some different understandings of that, or you're both here, obviously, you just said, to resolve this and come to some resolution. But Mr. Haskins, you're saying, you're willing to put in whatever time it takes, and Ms. Gill, you're saying, let's check in after a couple of hours and see how things are going, because you really...
Yeah, I think that's what we've discussed. We feel comfortable with is we want to see some progress being made and some real communication happening.
Okay.
So, by the same token, I'm sure that within the time frame the counselor has been talking about, I would think that we should be able to do what we need to do. Okay, good. All right.
So, just a couple of other things about the mediation session today. Sometimes in mediation, it's helpful for me, it may be helpful for me to speak with you separately. You can ask for that, or I can bring it up and you can let me know whether that would work for you. I could speak with both sides, I could speak with one side. So that's an option, and sometimes that helps people to just have some one-on-one time to get clear about their own next steps in the mediation. You also can certainly ask for a break at any time that you'd like to. Sometimes that's helpful as well. And if at any time you want to speak to your attorneys, or attorneys you want to speak to your clients, that's perfectly fine as well. Just let me know, and we'll do that. We'll take that break and give you the time that you need to talk with your client or your attorney. Just a couple of other things. Sometimes in mediation, parties set some guidelines or ground rules for the way that they would like the conversation to go. I don't know if that's something that you would like to do, so I'm checking in with you to see if that is something. Are there any specific things that you would like to agree to before you enter the conversation, or things that would help you to have this conversation in a more comfortable way?
We definitely want to limit the scope of the conversation to the matters at hand. Again, we're
that's appropriate.
Hoping, obviously, hoping that it's we'll see what happens, but we want to reserve our right to go in another direction should this not reach a resolution.
I have no problem in that regard. We've already been going in another direction. We have litigation that's ongoing, so certainly, as we sit here today, if we can focus on what we can do about that, I think that would be appropriate. after I had my discussion with you, my understanding is that we're here to have a conversation. And as long as we can have that conversation, that's fine. I don't think there are any necessarily limits or preconceptions that we're coming in with in that regard.
Okay, so
I want a conversation with Tom about what's happening here, about what's happened to my building, about what it's been doing to my reputation, about the damages I've suffered. I've spent a lot of time trying to reach him, get through to him, have an opportunity to actually hear from him what he thinks, what is going on, and so on. To me, that is a really critical part of us getting anywhere. I mean, part of the reason I'm here is to have a conversation with Tom. And I mean, I understand I'm represented by counsel, and Tom, you're represented by counsel, and you know, that's probably going to change the way we'd have a conversation, but it is important to me to hear from you.
Well, I think go ahead. I was going to say that there's only one basic problem with that, is that you started a lawsuit here, and that is the salient issue that we have at hand.
I think the salient issue here is, do you want to settle this case with me? And if you do, he needs to talk to me.
I think that the issue is not whether we settle the case here. The issue from our perspective is whether you're going to eliminate this case and get rid of this case.
So right off the bat, you're really
he
talking...
has to talk to me. Whatever it is you think the outcome is supposed to be, if he sits mute, it's not going to happen.
So right from the very beginning, I'm hearing a little bit of some differences in the way that you're choosing to have this conversation. There's some differences about whether or not this case is going to settle and what's going to happen in this mediation session to support that. Mr. Haskins, I hear you saying that since Ms. McFarland started the lawsuit, that's why you're here today. Those are the things that you're going to focus on, and that's what really matters in the way that this mediation takes place. And Ms. McFarland, you're saying in order for this to get to settlement or get anywhere for you at all, you really have to hear from Tom directly. That's why you're here today. You want to have that conversation directly with him.
If I wanted to talk to his lawyer, I'd let my lawyer talk to his lawyer in court.
Yeah, and let me just jump in. I mean, settlement is certainly one separate issue, but that's not what we're necessarily here to talk about right now. We're not going to just jump to let's talk about settling. I think we have some grievances that have not been heard, and we, my client would like to share those grievances first, and settlement will depend on how that first conversation goes.
I think realistically, we're not talking about a matter as far as settlement here. We're talking about a matter as far as discontinuing this lawsuit. You've filed a lawsuit against my client here, which the lawsuit is for $1 million, and quite candidly, I think as an attorney, that there are problems with this suit. There's statutory problems as far as the statute of limitations, and quite candidly, we're considering our own counteraction here with regard to both the fact that you brought frivolous litigation in the first place, and second, that your client who's sitting here today and the other people involved with the center have been involved in libeling my client. So, there are certainly some significant issues that could be brought. And I think that if, I know we're here to bring this to a halt.
I haven't heard him say a word. If we're here, Tom, you need to talk to me. We're open to talk about this, but you've hidden behind your receptionist and everybody else.
I'm sorry, as far as, talking about
you are irrelevant
where
to
he's
me.
hiding.
I want to hear from him. I mean, I said this to you in the original intake. The point is to be able to hear from him, something come out of his lips for the first time in years.
So again, you're really, how this conversation unfolds and who's having it is really central. And I've heard a couple of different things and some differences about that. Mr. Haskins, you said a few minutes ago that, the reason that you're here is because this lawsuit was brought for $1 million, that there's libelous claims happening. You could turn around and you're even considering a lawsuit of your own because this was frivolous in your opinion, and that you have questions about the statute of limitations, and that's what you really want to focus on here. And Ms. McFarland, again, you're really saying you want to have this conversation with Tom directly, and it sounds like there's some anchor around that you could be sitting here across the table that this
he
is the
talks
purpose.
about libel. My reputation has suffered because of what you did to that building. Because I have leaking roofs, I have weeping walls, buckling floors, injured children. Do you know what that does? I mean, just they are the most important thing. And I'm an educator. They're being injured in the building you built, and I can't even get you to pick up the telephone. And now I'm supposed to sit in a room and listen to your lawyer pontificate about what he thinks are the important legal issues. Your conversation can happen in a courtroom with my lawyer.
So it's almost like you can't believe that Tom would be here today and not understand the impact that this has had on your reputation, on the children, on having them injured, that this has been so really, really serious.
And that he's continuing the exact same behavior that caused there to have to be a lawsuit in the first place.
While my presence here may seem something that's irrelevant to you, the problem that we have here is because you brought a lawsuit. That's what brought us here today.
Is he going to talk or not?
Counsel and I, as far as the legal issues, which need to be resolved in this matter.
If we're going to have
the legal issues are part and parcel of what happened to make the lawsuit happen in the first place. So I think we're going in circles. We can't talk about dropping the lawsuit unless we go to the very beginning and talk about what's happened and see if your client wants to address that and maybe come to the table.
I'm perfectly capable of talking about what happened at the beginning. My client...
You weren't there and you're irrelevant, and I don't want, I didn't come here to talk to you. I realize you have to be in the room, just like she has to be in the room because there's a lawsuit, but I came here to talk to Tom. And Tom, if your position is you don't want to talk to me, just like you haven't talked to me for the last 2 years, I don't know why we're here.
We came here on the basis that was fully understood and expressed to the mediator that I was going to be here to represent my client, and that I was going to be the person who took the lead.
She's very emotionally offended that she thought she had a working relationship with your client, and your client just has not responded to her calls and ignored her. So I think she wants to try to reach out and see if he wants to talk to her directly.
So Ms. Gill, you're reiterating that this has really been difficult for your client, for Ms. McFarland, and that's part of the problem. Yes, there are legal issues that need to be addressed, but this problem has to do with that they haven't been able to communicate, and that's really important and salient for your client in order to be able to move forward.
Yeah, I think there's been a lot of insult to injury regarding what's happened. Is just the fact that he's been so non-responsive.
Well,
we are willing to talk to him. We are willing to see if we can have a conversation in lieu of the lawsuit.
I do not believe that it is anything approaching accurate to say that my client has been unresponsive before he was hit with a lawsuit and before he was hit with letters that were circulated around the community that's libeled his reputation, that basically has it's harmed his ability to make a living.
Well, the lawsuit has happened only in the recent 2 years. But however, the issues with the building go back as far back as 2002. But in 2007 is when we actively tried. Kathy, on behalf of the daycare center, actively tried to reach out and have him work with her.
My understanding at that point in time was that there was a message from her, non-specific, and that was the extent of the contact that was made at that point. And I would also like to say that the issues that you're talking about...
There were numerous, and you don't know. You weren't there. You just arrived on the scene like from outer space. Tom, I need you to... You don't matter.
So Ms. McFarland, again, you said to Mr. Haskins a number of times that he's irrelevant because you want to talk to Tom directly about what's happened.
All I know...
And that's...
If he is going to talk, we should be in court and let him write his briefs and talk, because the issue is between us. It's about what happened to that building and how we can find a way to fix it. And whatever issues it is you have. I mean, I saw when he mentioned the letter, you rolled your eyes and looked at me. If you have an issue with me about that letter, I'd like you to tell me about that. Not him. I don't mean to say you're irrelevant as in your job is irrelevant. I mean that we aren't going to get anywhere as long as he's the only person talking and she's the only person talking. If that's where you want to go, then we need to go to court and just, pay the bills and get on with it. And this is the same thing as talking to your receptionist.
So you're saying that this is, again, you feel like you've hit that, it's the same as talking to his receptionist, not being able to access or talk directly to Tom about what's unfolded, and that's just been very offensive to you, and it feels like that's continuing even in this mediation session, where your attorneys
He isn't here in good faith.
I'm interested in my client's interests. My client has interests which you have harmed.
Well, we can say that there's been quite a lot of harm to us too.
Initially, the problems that you had after.
Blah, 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 blah. I'm not here to talk to you. I'm here to talk to Tom.
Counselor, perhaps if you could at least keep your
you
get
know
your client
what?
to be
No,
at least
this is
moderately
my
respectful.
So again, there's some differences about who's having this conversation and what it's going to be about. And one of the things that I'm hearing you say is that there has been harm on both. That's one of the topics. And Mr. Haskins, you're saying your client's been harmed, his reputation. There's libelous. You have some real concerns, and that's why you see you're here today. And Tom, you're nodding at that. And Ms. Gill, you're saying they don't have the corner on harm. Your clients also experienced
and I
something.
Also, the mediation is to give them a chance to talk without getting the lawyers involved. I'm here to support her, but she really wants to have a chance to talk and possibly work it out with Tom. So, the mediation is the chance for the parties to talk to each other.
The problem is that you have him here.
The problem is you have no interest in working this out. I mean, you just want to lecture me about my case.
Anything to do with him. You've got problems that came up years later. It
isn't liable to tell the truth about what somebody has done to you. And so if you think you're intimidating me by ringing libel bells, you're not.
You're right. The truth is a defense to libel. However, what those letters that were sent out said about Tom and about his work,
I believe,
were not the truth.
They were the truth.
The building only came to being when your client made the building. He built the building.
Which was 12, 13 years ago. The problems that you have that you're complaining about here, they emerged in 2007, back at the point in time when the facility decided that they wanted to do something about air conditioning, and they put this monstrous unit up on the roof there with subsequent problems.
That's a question of fact. With the air conditioning should not have compromised the integrity of the building. How can you say that there should not be air conditioning in the building? It gets hot in the summer.
Tom didn't put the air conditioning up there. If there's problems that have related to that, if you've got leaks that go back to that point in time, those are not of his doing.
You're assuming
the
leaks.
Party on the other side
This
of the
is classic of him. We have the wrong party. He doesn't talk to anybody. He sits in a room and lets his mouthpiece talk for him. He's never present. He's not present on his own business. He doesn't stand behind his own business.
So again,
and that's how we get here. We get here because of his attitude of making promises to people and walking away, and then letting strangers to the entire event do all the talking.
So this for you is, again...
This is just more of the same bullshit that we have heard from him for years and years and years. And I might say, we called him about the air conditioning, and he didn't even bother to return any of those calls. We have tried to work with him for years, which is exactly what's in the letter. It is your complete indifference to what happens once you finish a job. No matter how shitty a job you do of it, you walk away, and then you become a ghost. And you're a ghost in this room. You're sitting here, a ghost in this room
So for you, Ms. McFarland, it feels like you're angry when you see him sitting here and not saying anything. It feels to you as though the same...
It infuriates me that he's sitting here. Why are you wasting my time? If you have nothing to say, why did you make me come here? Let's just freaking go in front of the judge and let this man talk for you the entire damn time.
What I'm getting from your client is a collection of emotional misstatements and mischaracterizations of the events that occurred.
Well, we're talking in circles. We haven't even started to talk about the events that have occurred.
This entire thing started because I simply asked him to say something. And that seems to be like completely against your game plan. Clearly we came in here and you're just going to talk to my lawyer. That's your plan? I'm just telling you that is not...
I am here to represent my client.
Right. Are you going to say anything?
Talk to my lawyer. That's
I'm
what
not
I'm saying.
interested in talking to your lawyer.
You're the one who writes nasty letters to the whole community You're slapping with $1 million lawsuit. That is not what you do to somebody who doesn't answer a phone call. First
He
of all,
doesn't answer 2 years of phone
you-
calls, Tom. I mean, you haven't addressed any of these things. I have yet to see anything from you, not from your lawyer, but anything from you for years talking about anything you were going to do with that building. You sat in silence.
You have turned this into a legal matter. The lawyers have a role to
And if
play
it's a
here.
legal matter, that can be settled in court. The question is, can we avoid continuing to fight with lawyers, or can we come to some sort of resolution?
This is what you get when you send
So
a
the answer is no. In
send
other
a
words.
lawsuit.
So when
Is
you,
the answer
But then
no?
why are we
The answer-
here?
Then why are we here? If a lawsuit would be settled in court, we agreed to do something outside. Why are we here?
so a couple of things that I've heard you say. One is the way that this conversation, again, we're still talking about the way that the conversation is going to happen, where you've been talking about a little bit about what went down, and you see that really differently. One of the things, Tom, I heard you say was that the reason that you get what you get a lawyer talking to you now, is because there's been letters out in the community, and
So
and that doesn't.
if you want to fire a nuclear, missile, this is what you get.
Mm-hmm.
So talk to my lawyer.
But a nuclear missile is what you get
Is a
when you
$1 million
ignore
lawsuit.
when you ignore
So
when
deal
you
with it.
ignore years and years and years of
Yeah, but why
requests
don't we
that
talk
you
about
say
that?
something.
Why don't we talk about?
Wait. We're not just here for you to attack my client. That's why I'm here, so that this is not going to happen.
Okay.
Right.
You've been engaged in this enough
Right.
out in the community already.
Right.
So,
Well, did you really think I
So
was
this
going to come in here and sit
mutual
here and let
reputation
you pontificate, in your blah blah blah, and not say anything? I mean, I was supposed to do what? Say, "Oh, excuse me for suing your client
So, Ms.
for
McFarland-
building a building that is killing my business and my kids
So,
and
Ms.
my
McFarland,
reputation."
Hyperbole is
it
not
sounds
gonna
like
get
you're
us
saying, what did they expect?
Yeah.
You've had this your reputation's been affected, children have been affected. Yes, you're livid. Yes, you're angry. You feel he hasn't responded to you. It's been 2 years, and now is the time that
And then
you
he's
want to
surprised I
have.
sue him. He's surprised I sue him. He sits there and
So-
doing nothing for years. And then he goes, "What? You filed a lawsuit against
So
me?"
just the fact that he's shocked that you sued him is troubling at best. It's unbelievable.
It is.
Okay.
It's unbelievable.
So I
It's
want-
unbelievable.
So I want to check in with you. You've talked about a few different things. You've talked about having some direct conversation between Ms. McFarland and Mr. Chu. Mr. Haskins, you've said the reason that you're here is to protect your client. Ms. Gill, you've talked about really wanting to, get some things on the table to get this conversation started, and it's more than just the legal issues. So I want to check in with you to see, where you'd like to go from here, where you'd like to go now.
Well, quite candidly, I think if we could focus the discussion a bit more on the issues that are at hand, rather than just having a session to malign my client, I think that would be.
If you're here to defend your client and that's the only thing that's going to happen here, then we're done.
Okay.
Then we're done.
So you're saying that this is going to be over and done if
I
Mr.
can- I
Haskins is the only voice you're going to hear from that side?
That's right. It's pointless.
Mr. Haskins, you're
it's
talking.
an absolute and complete
no.
and total waste of time if the only person who's going to talk in this room is him.
My client has asked if we could take a break for a moment,
Yes.
so that we can discuss things.
Is that okay with you?
Yes.
Okay.
I
So
think
we'll.
this is certainly a point when it might be helpful.
Okay, we'll step out and let you have a few minutes to confer, and then you can. I'll check back in to see if you're ready to resume.
Very good.
And you can certainly.
I really have a question, Tom, as far as how this process is going, because all she wants to do is jump up and down and yell at you.
That was crazy.
Yeah,
It
well,
was not what I thought we were doing today. I had a really hard time sitting for the last few minutes.
well,
I had no idea from whatever you said to the mediator on the phone the other day. It's totally different than what I expected. I mean, this woman just blew me away, and here I was doing what we said we were going to do. Right.
right.
I'm the contractor. I
Right.
build buildings.
Right.
That's my specialty. You're the lawyer,
Right.
and you're supposed to solve my legal problems.
Well-
Which you're doing a very good job of
Well-
defending my legal interests, by the way. But this woman is, everything she said to me, I was just like, it was like a hail of bullets coming at me, and I did what you said you were going to do, which is,
you know, that's all well and good, but you know, unfortunately, you know, what I was envisioning here was more of an interaction with her counsel, who you know, doesn't seem to be in play here at all. So
yeah. I mean, honestly, I don't. How are you going to get us out of this thing?
Well, certainly we can always continue with the litigation. I think we can win the litigation. The question here is what you're going to be able to do about her.
Well, the thing is that not only is she a loose cannon. I mean, these letters are out there, right. So my reputation is like already just sunk. Basically, this woman needs to retract these things.
We're engaged in litigation, and you know, the end of the line in litigation is, you know, money damages. Now I can get you money damages in the lawsuit, but you know, if you want to deal with other issues with her, you know, that's not really what we're about.
And what I need to do, this is a very small community. I mean,
Yeah.
all of my clients or potential clients have people who either went to this daycare center or are gonna be using this daycare center, including apparently there's a kid who had a slip and fall, and now they're claiming that my, you know, incompetence or whatever the supposed stuff in these letters is basically they're linking this slip and fall with my work from over 10 years ago.
Right. Yeah.
So
I agree. That's totally.
I mean, it's
inappropriate.
insane. But the thing is that sitting across from Kathy here and not being able to say anything it wasn't just hard, because basically by not responding to her, I was basically allowing whatever she said to be taken as truth.
Well, I guess the question here, this is a confidential process. So what goes on here is essentially staying here. My inclination as an attorney is to, you know, I want to beat them. I think we can beat them.
I
But
do too.
even if we win, she's going to be a problem for you out in the community.
Well, and the thing is that I need to really confront Kathy on these things that she said. I mean, these claims that she has made are really unfounded. So, you know, so damages, no damages. I mean, obviously, I'm not giving her $1 million.
Right.
And I trust that you're going to make sure that we're not in for that. When we get back together, I don't think it's going to work for me just to sit silently again. It just,
Yeah.
I mean, not just, you know, hearing the ballistic stuff, but just also, you know, I need to be able to respond and like be very honest with this person.
Well, our game plan going in, as you and I discussed, was that I was going to be here taking the lead and representing you in this matter. You know, obviously, you know, based on her attitude and the level of emotion she's got, and I guess too, listening to you based on some of the things that you've said, that you're going to have to deal with confronting her at some point. You know, the question I have to you is whether you feel comfortable in engaging in an actual discussion with her at this stage. You know, is that something that you think would be appropriate?
Well,
because you are the client. You know, I can advise you, but you get the end decision.
I mean, I just cannot walk out of this room having heard all the things that I just heard and not respond to them. I mean, what she made it sound like was when, like, for instance, the whole claim of unreturned phone calls. The woman had called one time and left a message.
I know that.
So, you know, so if I don't say something, which I know, I mean, I've been like very kind of
I know you've
good
been,
to, you know, our
you've been
agreement.
a marvel of holding back here.
But, you know, but that's, I mean, even I realized like at the end I wasn't really kind of following that anymore.
Yeah.
Because, I mean, it's not just being baited. Because there's a truth behind this. I mean, I did my absolute best job. The whole claim of the air conditioning was, I thought you did a very good job of defending my position.
Well, thank you.
But, you know, but the thing is that she's made this the cornerstone of all these claims and all these nasty letters.
Exactly.
So, you know, I've got to figure out, like, beyond the getting rid of the lawsuit, beyond, I mean, it's really the reputation issue. I mean, I need the business.
Right.
I need to come to some kind of understanding where we can kind of get to the next place. Right. Because the truth is that I had nothing to do with this leak since the new air conditioner went in.
Of course.
So, now she has not acknowledged this.
Yeah.
And even though we put it in writing, you've had all kinds of responses. I've seen everything you've done. You're doing a great job for me, and yet it's not getting through to this person. So my question for you, counselor, is like, what do I do now?
Well, based upon what you've said, I guess the question is, and you're the one who's going to answer this, do we want to change our game plan here? Basically, she doesn't want to talk to me.
It's not working.
Do you want to go forward with talking?
Only if she doesn't use foul language.
Okay. Well, I think.
That really set me over.
I think we may need to set a ground rule there.
That's
it's one thing
out
if we're
of
going to
bounds.
if we're going to have a discussion. It's one thing to have a discussion. It's another thing to have a stream of consciousness session where she's just
pretty much
dumping on you with any
yeah.
obscenity that comes to mind.
Yeah, that was pretty grim.
Okay. I think that we can talk to the mediator about that and see about setting that as a ground rule, and then I'll step back. I'm here to here to guard your interests, but I'll let you.
Honestly, I almost don't really want to go there. I'm feeling. I'm hurt, but now I'm actually kind of a little mad.
Right.
And I cannot leave this room, even like with a stranger, having heard all this stuff being said about me that's like completely false.
Without making the effort.
Just to be able to respond. To be honest, I could not have imagined what I just heard.
Well,
you could not make this up. That was amazing.
No. You don't see.
This is the daycare
explosions
center.
like that every day. Yeah. Well,
I hope the kids don't hear
dealing with
this.
an issue like that.
But
yeah.
Okay. Well.
All right. So why don't I?
I'm a little better now than I was 5 minutes ago.
Again, I'll get them back in, and we'll talk to the mediator about setting a ground rule, because obviously we can't.
We're not having that.
Yeah. No.
No. I mean,
that was totally inappropriate. That's out of bounds, out of hand. I'll go get them in.
So we've had a few minutes separately. You had asked for some time to speak together. So we're back together now. I don't know where you'd like to begin.
Well, I do have something, a couple things to say actually, going back in. My client and I have spoken. He has determined that, obviously the two of them need to have some discussion here. So, irrespective of the fact that I'm here to represent my client, I will allow that interaction to take place. However, we do need one ground rule. We cannot have any obscenities. We cannot have the level of vituperative comment that has gone on previously. If we can have a discussion that can be within civil bounds, that's fine. But no swearing. That's inappropriate.
Okay, so you'd really like to. Your client is going to talk, and the one thing that you're really clear about is that this can't go on and be vituperous, or there can't be any swearing, or it has to be civil.
We don't mind having a discussion. I understand that there are emotions at play here, but I don't think even within that realm that there is an appropriate place for swearing at each other. I don't think that's right.
We've also had a few minutes to talk, and we do appreciate that you're willing to, give it a chance to talk directly with each other, which is really why we're here. I do appreciate your comment. We've had a chance to talk about things as well.
Okay.
So we are again here to see if they can have a productive conversation. Okay?
Okay.
If I can just say thank you. I mean, it's important to me that you're willing to talk to me.
Which is the only reason I'm here. I mean, if we're just answering a demand or responding to a lawsuit, we wouldn't have agreed to have this. But now that we're kind of having a different agreement of how we're going to be together, I'm okay with having the conversation. But the thing is that I'm also promising to basically walk out of the room if it gets beyond the normal scope of conversation. I mean, what I just heard, and it was I have to say, to my attorney, that I had never heard anything like that in a room before.
Your silence, I have to tell you, your silence just pushed every single button I have. What I really wanted most of all, and have wanted for a long time, is to have some sort of problem-solving conversation with you. So, you know,
We could have had it a long time ago. But the thing is that what you said a number of things earlier that I really need to respond to this, which is why we needed the break so that we could kind of reconfigure, you know, how we're going to be at this table. Because as you could see, basically the way that we've arranged to be here is that I'm a contractor. I build houses. I build schools. This is my attorney. He deals with my legal problems, and that's our arrangement. We kind of divide the work, and that's how we had agreed. You know, and I was in the room when you had the first conversation.
Right. In essence, this is a legal problem.
It's a legal problem, and so my being silent had everything to do with, and certainly was something we arranged in advance with the mediator. So I didn't, you know, so I was acting completely within what we'd agreed upon. A few minutes ago, basically, we decided that, okay, well, let's have another conversation. So for the moment, we're both speaking, but on anything that has to do with the law, I'm leaving to you.
That's still on my side.
Okay, so let me just make sure. So Tom, you've said it, or Mr. Chu, I don't.
Oh, call me Tom. Tom's fine.
Okay. So what you've said a couple of things. One is that you had arranged, you and your attorney had arranged to split up the work, so to speak. He was going to handle the legal piece, and you had agreed that he would be speaking for you. That's just the arrangement that you made before you came in, and that was the intention. It wasn't necessarily, I mean, you haven't said this, but you're just laying it out that that's the arrangement that you have. You build houses, you build buildings, and he handles the legal stuff. And that's what you intended for this, not to, you didn't actually say this, but it sounds like you're saying that was the intention, not anything else.
Nothing more.
Nothing
and the
more.
thing is that once things, you know, went the way they did just now, you know, all I could really do is kind of ask for us to have like a little time together.
So
I think,
You know, I have
I'm
to
okay.
say, we also talked to the mediator. We also had what we understood to be an arrangement. And the thing that we emphasized was the need for you and I to talk. So, I mean, I realize that conversation wasn't happening across here, but if you are saying to me that you were offended to find out I was so angry, you can imagine how I felt, thinking that the entire purpose of us coming was that you were going to talk to me for the first time. So to sit here and have your attorney, you know, calmly lecture me about why you weren't going to talk to me was just surreal. Absolutely surreal.
So you were really expecting that you would sit down and be having this conversation with Tom directly, and it was a shock
That's
to
right.
you to hear that his attorney.
Totally floored. I expected to sit down, as you say, you build houses, and frankly, that's what I'd like to talk about. I'd like to talk about the building and the things that need to be done in order to get that building going, how that costs and what the effect is.
What's happened to your building?
Right. I'm not, you know,
Fine.
and so the lawsuit brings the lawyers into play. They're going to fight it out. But this conversation is like, can we do something about this that doesn't require either
Let's talk
of us
about
to
the
do
building.
that?
Let's get
Yeah,
down
let's
to
talk
the
about it. That's fine.
I think that would be appropriate.
Okay, so now the conversation, you want to talk about the building. Where would you like to start with that? Tom, you were beginning to say something.
Well,
Kathy?
yeah, since I haven't said very much. And it was, I have to say, it was like pretty hard to be sitting back here when basically the whole room was talking about me, and I was doing what I.
You have a chance to catch up.
Okay, so now I'm going to catch up. Okay, so 2001. This is 12 years ago. Okay, none of the children at the daycare center were even born yet. Even their elder siblings haven't been born yet. That's when I went into contract with you to build what was the best, most modern, waterproof roofed facility possible. Okay?
Except that it leaked.
I'm a contractor. I'm not an architect. Okay? Everything was to code. I built it according to your architect's plan. I submitted a bid. I was under budget. My workers showed up. I have all the workers' comp, all the liability insurance. I'm the most above board contractor.
Okay, then let me
in the entire.
interject.
Please, no. Let me just finish. This is the story, and let me just like kind of take us back to the beginning.
This is
here.
your story.
Okay.
We should hear it all.
This is well, and we have. I mean, come on. I mean, when you want to get into the paperwork, that's all documented.
Right.
Okay?
But what is
and
also
the thing
documented is that the roof leaked
Now,
soon
let's-
after you
And that's a
built it.
building
Now,
that's been a
listen.
consistent,
So
continuous.
one of the things I heard you say, Tom, was that this was many years ago, starting in 2001. So that's something that you want kind of on.
let's get clear about this.
And you had
Exactly.
all of everything was correct in terms
Signed
of
off on,
the
inspected,
workers' comp. Your workers
stamped.
showed up.
You have it all filed.
And then it's leaked.
Certificate of occupancy.
It's been a
all on file.
continuous series of problems every day since you walked out of the place.
When there was
and
a
at some
leak,
point you just
when there
decided
was a
to
leak
quit
in 2002,
correcting.
I actually came at my own expense because it was still under warranty. I mean, even though I'm not a lawyer, I do get this, it's in my little form contract that I stand behind my work. And I came back in 2002, and when I saw that there was a leak, and I decided on my own inspection that it was part of what I had agreed to do for the daycare center, I fixed that on my own accord. Okay, you did not within a year, and there is actually a countdown that begins once you actually hand over the building. Get
I
this.
talked to my lawyer too, and I know that you can't contract your way out of certain of your
Not within
obligations.
10 years.
Not
The
within 10
building
years.
is
So
supposed to
so
last
you
much
so
longer.
that's an argument for them. Let's you and I talk
but the
about
thing
what
is this-
happened to that building.
Well,
So,
that was a long
not the
time
legal
ago.
issue.
Kathy, right now you're talking about, that you have talked to your lawyer. There are certain things that you can't contract out of, but you want to talk directly to Tom about other things other than the legal issues.
That's right. I want to talk about the fact that in spite of all the sign-offs and everything he says he has, the building roof leaked, and he came in and fixed that. And then when the next set of problems started, you couldn't get him on the phone. Then now he's trying to pass these things off onto air conditioning and items
Yeah.
like that. But the fact of the matter is it's a disaster area. This building, things are constantly leaking. Things are constantly the floors are constantly coming apart at the seams.
When you in 2007 brought in, this is years after I finished my work, okay? You bring in some, fancy HVAC contractor to put this huge air conditioner that you don't even need one of this size on your roof, which, by the way, is not rated to hold this. Of course it's going to cause leaks, and it's totally honest.
You cannot conclusively say it's the air conditioner that caused the leaks and not your work. And we've had an expert inspect the building that
Counselor,
has told us.
are you going to double team him here, or?
I thought we were going to have a one-on-one conversation.
My point of letting my client have this discussion was to have this discussion.
But
Okay,
but when you
so
talk,
one of the things I've heard a few different things. One of the things I just heard you say was, and there was some disagreement about this, about the actual unit itself. So there's a couple things. One is who's talking to who right now, and the other is the actual unit itself and whether that was the appropriate size. Ms. Gill, you're saying you can't conclusively say that. You have an expert that says something different.
Yes, and just to your point, is we didn't want you to completely dominate the conversation, but we're not asking you to be completely silent either. If I see something or hear something that I need to step in, I will.
I mean, I heard you sit in here, him talk about, that we libeled you in a letter.
You
We
did.
sent around a letter basically saying that the building you constructed, had problems that were created at the time
Without
of
even
construction.
sending me a copy of it. You sent this to all these people who actually, this is a very small community.
That would be
You
what
don't
we
do
that would
that.
be what we
You
would
don't do
intend
that.
to prove it in court.
You wanna
but
shame
you
somebody, you
didn't,
might do that.
Well, yeah.
So
no,
yeah,
I don't think.
and that's what you want to do on.
So
I
when
had
you talk
tried-
about this letter, when you talk about the letter going out into the community, you have some different views about that and what its impact was. Kathy, it sounds like you're saying you had to send something around to let people know that this was the situation, and it goes back to the building when the building was
And
constructed.
I couldn't get him to
and
respond
that it's
before I
all
sent the letter.
Tom's
I
letter.
tried to get him to communicate with me before anything was happening. I left him voicemails. I told him that I was in a situation where we had an injured child, we had problems, and I needed to respond. Would he please call me? And I hear nothing. And then he complains that he didn't get to say anything or have anything to say about what was in the letter. You've had so many opportunities to work with me to try and make this building a showcase, and your response just like your response today has been, I don't know, to shove it off on somebody else and to be silent. So it's like you don't have records. What, your receptionist didn't keep records, I guess. So now that's her fault. It's the air conditioning man's
So you're
fault.
saying that you did try to reach out to him before you sent any letters to try to get him to respond.
I have
talk
tried
to him
to-
about the air conditioning. You didn't get any response, and so
some
seemingly
point
at
we
your
have to
wits end, you sent out the letter.
Right. That's right.
And-
Exactly. I would.
I don't
this
have
was a
anything to
crisis
do with any
situation.
air conditioning. The contract, which I completed on time, under
You know,
budget,
even
with a
with-
C of O, did not have any air conditioner on it.
This
So when you
doesn't
get
have
an air
anything.
conditioner
This
after
doesn't
the
have
fact
anything to do
and
with the
punch
air
a giant
conditioning.
hole in the roof, which I repaired at my expense, that's on you.
So it sounds like you're saying, Tom, that when Kathy decided to put in this giant air conditioner,
Yes.
that
Out
had
of
nothing to do.
warranty.
That had nothing to
Takes
do
it
with
out
you
of
anymore.
warranty.
You
It's just
came
like
back.
when
It is
you
not
buy a car
inclusive.
and you jack it up with a fancy new tire or a new
You know-
piece of equipment in the engine, that's no longer serviceable under warranty. Same deal. Do you understand
yeah,
that?
I do understand, but I also understand
know
that
how-
the air conditioning unit has absolutely nothing to do with this. It was
Except
built,
for this on the roof.
It was built. It was
and-
built by. It
and
was.
it rains.
it was-
How does that have nothing to do with the
Well,
fact that it could actually be the cause of all the leaks you've had, including the.
But it wasn't the cause
the
of the
floor
of the
coming
of
up
the
and the
leaks.
slip
It
and
wasn't
fall.
the cause of the leaks and the various problems we've had from
And
the building.
they had an expert
and
examine the building.
you know, essentially, we have to get other reputable contractors who experts say the work is fine and so on, but we had to go get somebody else because we couldn't reach you because you were completely unavailable. So it's
I'm
your total
afraid-
abdication of the
I'm afraid that this
responsibility.
characterization here is problematic to our discussion.
It's
because
problematic to
the
your
only-
case, but it's not a mischaracterization.
So when you-
this is the,
So-
this is the truth as I see it.
Well,
Absolutely.
your truth is really distant from the reality.
It's really distant from
Okay.
your truth. I
The reality is you have a $1 million air conditioner
The reality
on
is
your roof.
the reality
okay?
is
It weighs 4 tons, and you putting
Now,
a
that's-
4-ton air
now that's
conditioner
problematic.
on a roof which I had nothing to do with. You called someone else to put it in.
So in,
Conjecture. You don't know what it weighs. You
I
don't
know.
what
I
it
look at
costs.
any
You
contractor
haven't
look at
even-
this
you haven't
and
even come
estimate.
to the
It weighs
building.
about a small
You haven't come
car.
to the building.
So one of the things I hear you saying again about this air conditioner, what's really, whether it is or isn't, you have some differences about that. Ms. Gill, you're saying again, Tom doesn't know what the real situation is with the air conditioner.
Doesn't
You've had some
matter with that air
experts.
conditioner.
You are taking a look at that. You've taken a look at it, and he doesn't know for sure. And Tom, you're saying it's too huge for that building.
Absolutely.
It sounds like you're saying it is
Why would I give you
attributable.
advice about it if you just asked me.
we
I mean, I
did. We
built the
asked you
building for you.
repeatedly. For God's sake,
No,
we
you went
asked
out of town.
repeatedly.
You went into another county to get some other company to put in.
We managed to get funding. We had this great opportunity. We wanted you to come in and do the work on it. And there were other issues with the building that we wanted to get resolved at the same time. If we went and got somebody else, it was because you never returned any calls. You never took the business. You were uninterested in us. You were done, and you just wanted to walk away. The building.
Irrespective of whether there was some failure to get in touch at that point in time, someone else did the work. And I would point out that according to your pleadings here, the leak started in 2007, post the point in time that the air conditioner was installed.
But you cannot determine that the leaks are because of the air conditioner, and we've had an expert say it was because of the roof.
Yeah, well,
And this lawsuit isn't just totally isn't about leaks. It's also, the floor wasn't properly sealed in the first
Well,
position.
if you have a leak constantly going on in the floor, it's obviously going to affect the floor.
I mean, we have a series of issues. The leak was the symptom that broke the camel's back, but it was not the only problem we've had with this building. And
Tom built the building. Tom did not design the building. Tom was not the engineer on the building. He built
that's right.
the
So he
building
was responsible for
according-
stretching the rubber across the
Let him
floor.
finish.
He was responsible for building things according to the instructions and the plan of the people that you hired to handle that aspect of things. Performing his work in an appropriate fashion is something that he's got a reputation for. Yours isn't the only first or last building that he's built. He has a good reputation in the community, and the fact that your building had problems is something that,
It's unfortunate that he did not perform to his normal standards on my building. I'll agree
Well,
to that.
yeah, I guess that's the question here. That's the question.
I'm not going to accept
Well,
that.
that is the
Because-
question.
I'm not going to accept that.
We don't believe that that was the case.
So when you're talking about the construction of the building and whether it was done correctly and appropriately, you have clearly some differences about that.
Oh, yes.
And
And do you want to
you're-
litigate those differences?
Look,
Isn't
you
that
got-
the question?
you got-
That's the question.
you
because
got a
we feel
certificate
very,
of occupancy.
We feel very strongly that we are going to be able to show that your building was substandard. That's if we didn't believe that, we wouldn't have brought the lawsuit. So now you're telling. I'm hearing
Sure.
you say that you believe strongly you can defend it. But the question is that where it ends?
Where it ends is when you can actually write a retraction letter to all these people who now think that I do shoddy work.
You
So-
do shoddy work. I mean, that building is living proof of your shoddy work.
So Tom, for you, it's really that's essential for you. This is really at the
Absolutely.
crux is that there's some kind of
Absolutely. Otherwise, we could have just gone ahead and just done the litigation route, right?
You've harmed his reputation. in the
By the
community,
time we get to
and
the end of
appropriately
this,
so.
by the time we get to this end of the litigation, and we go through all the problems that are in that building as you built them, your reputation will suffer that
I'd like
same
to
anyway.
make a suggestion. I think at the outset we said we wanted to see how things would go in the conversation. Well, I'd like to have a chance to talk with my client and with the mediator, since you all had a chance earlier. I'd
Yes,
like
I
to take a moment and take a break. And
Okay.
Okay.
I think that's appropriate at this point.
yeah, so
Okay. All right. So if you want to step out into the waiting area, we'll stay here, and then if you'd like an opportunity to talk with me, we can do that as well.
Okay. Very good.
That man seriously thinks I libeled him? Are you freaking kidding me?
So it's
Are you
Okay,
kidding me?
Stop. Okay, I think what we need to do is refocus what our goal is here. Because when you and I talked, part of the goal you were concerned is about the expense of litigation is going to hit you as well as him. And we were going to see if the mediation could somehow be productive. And I do want to help you in that, and I wanted to get the mediator's input in as well. We were trying to facilitate some understanding between the two of you. So I wanted to just stop and see where you want to go, because you also wanted to avoid a long and lengthy lawsuit.
Yeah, you're right. I don't want to.
So Kathy, a couple of the things that you said during the mediation, I mean, it's clear that you're really angry still and really upset with the way that things have happened. You've mentioned a number of times that Tom wasn't responsive to you, and Tom hasn't gotten back to you.
He's just avoiding responsibility. It's what he's doing now. And he's threatening me in order to avoid responsibility. I mean, if we go to a lawsuit and we start going down the catalog of just things that have been the matter with that building from day one, from large to small, his reputation will suffer. I mean, it's all in the documents. He can show you all of the certificates of occupancy he wants. It's just item after item after item. I'm not particularly interested in dragging his reputation through the mud, but I'm out $1 million, and he is responsible, and he should take some responsibility. And I guess it's, yes, you're right. I don't want to go through the expense of litigation, but there's no way in hell I am writing a contraction letter about what he has done to me. I mean, no, I'd sue him first.
No, I don't think that's a reasonable. I think they're shifting the issue away from what the issue is. It's really not about his harm, which is minor if non-existent. It's about this building.
I mean, how do we get him to even confront the fact that he has problems with his own workmanship?
If we want this to be productive, I do agree with the counselor that let's take the tone down a notch.
Okay, so how do I do that?
Let's try.
I hear you say that to me, but like I am who I am, so give me, I don't know, breathing exercises or something.
Let them finish.
What do you want me to do?
When they are speaking, I do want to give them a chance. We asked them to talk. Now Tom is talking. Let's let them
I'm actually really grateful for that.
So, they have made a step in that direction.
So when you say take the tone down a notch, you're really asking Kathy to let them finish what they're saying, let them say some of the things, and it sounds like that's difficult to hear, some of the things that you're hearing when either...
I guess,
Tom
I
or
can't
Tom.
really separate it from the same denial of responsibility. I've been hearing from him through his silence and indifference. You know, see if he's going to witter away his 2 hours
I
here
mean, what
and
I
leave.
would suggest, the time is being withered away. So what I would suggest is let's see where it's going to go when they return.
So you're thinking if he gets to
But
his
it's not-
say that he might then actually stop and start actually talking about some of the issues with the building? Once he tells us that there aren't any and it's all because of the air conditioning and he's perfect. If
So-
I just sit here in silence while he does that,
No.
you think he might start to actually then talk about the fact that it leaks and that the floor buckles and so on?
You're wondering if he does have this opportunity to say all the things that he wants to say, if he's then going to change his tune, so
Well,
to speak?
I'm not asking for promises. I'm just asking, you know, like, does that actually have some effect on them if I sit here? We'll find out.
Yeah, I mean, I don't know that we can predict that, but I as your counselor, I want this to be, I want to give it a chance to be productive. If it's not going to work and we can walk away, we can be back in court tomorrow.
Okay,
So
all right.
I wanted to take a break to ask, what do you want to get out of this?
I'm going to get him some portion of the $1 million that I have lost, and I want
Okay, then we'll
I want him to stop insinuating in the community that I'm the cause of all the problems in that building and that you can't safely have your children with me because of my decision-making process. I mean, the man is destroying me in the community, and you know, and he has had so many opportunities to behave responsibly, and you know, essentially he's just counting on the fact that we'll give up and go away. And you know, if I have to spend my mother's inheritance to make it clear to the community who and what he is, if this goes on, so be it. Okay, so let's try it. Let's try it today. I will sit here and do my damnedest to twiddle my thumbs, and I know.
Well, I don't want you to do
That's
that,
it.
but
No.
I you know,
But and you know, and who knows? You know, maybe he'll surprise me, right? God, people do.
So you're saying that you would like to, what you'd like to really see happen here, if it's going to happen today, is to get some of that money back, and that he stops going out into
I'd
the
like
community.
him to take some responsibility for what happened, and to me that includes taking some responsibility for it financially and taking some responsibility as a person in my community for what he has done to me. That's what I want.
and I don't think that's unreasonable. I don't think that's unreasonable.
Okay.
I mean,
Yeah.
they're really
And-
skirting the issue.
So the responsibility is both your reputation too, what he's doing to you in the community, and taking some financial responsibility for what you've had to put out.
If he's not going to do that, then I am perfectly willing to litigate till hell freezes over.
Okay, all right. I wanted to be clear on what your
That's
your
about
goal
as
is.
clear as I can,
Okay.
you know.
All right.
Okay.
Okay, are we ready to resume?
We are. Thank you for taking a few minutes, letting us meet. And it's did you want to also meet for a few minutes, or?
No, I think we're good at this point, thank you.
Okay. So we had just ended where you were beginning to talk also about, the work that was done, the building, getting in touch with each other, the letters that had gone around. So I don't know where you want to jump off or where you'd like to start.
Well, I just have one small thing I want to share, and we also had a chance to chat when you were out.
Mm-hmm.
And we do want to thank you again for being here. So I just want to say that again. I know we thanked you earlier, but we do want to thank you for being here and for coming to the table, hoping to find some common ground.
Well, I guess the question is whether we want to look towards what can be done potentially to find common ground, because obviously at this point there are some factual questions. I think that the way things stand now, there may be an issue as to whether we need to potentially work between us to see whether we can get a clearer idea of what the actual factual picture is. Because I know from the perspective that I've heard from you, from both of you in discussing this, the problems, origin, and timing don't necessarily comport with the information that we've had. and that our expert has come up with. And I know you were discussing how you've had someone look at it. We've had someone look at it. But, at this point we have, if we're going to deal with things on that perspective, we have some rather divergent, opinions that we've each gotten.
And I agree with you. I do agree with you. That's the whole nature of our issue here today.
Right.
Along those lines, one possible suggestion would be, okay, you know what, we have different views, we're going to disagree on the facts, on what happened. One suggestion would be to set that aside and see what do we want to do about it from here, just to come up with a solution. More money could be spent trying to sort those facts out, which is one direction, in litigation, or do we want to try to find some way to reach some settlement?
Well, I guess the question here is whether we're in a position that we can actually arrive at a settlement, owing to the fact that it's not entirely clear, certainly from our perspective, and I don't know whether it is from yours, as to what precisely needs to be done at this point. Because obviously, from both of our perspectives, we want to see the building whole. And quite candidly, whether you may necessarily believe this or not, Tom does take pride in his work and what he does. And that's important to him. If we're going to make the building whole so that it's something that both serves your purposes as far as being a facility that you can, without concerns or worries on a day-to-day basis, operate as a daycare center, and for us to look at it as to, well, what can we do to make sure that this building, as do the rest of Tom's projects, what we can do to make sure that that's in line with his reputation. I think that we really need to be in a position to be able to say something about what precisely needs to be done at this point to take this building back to the point where where it meets everyone's standards.
So, Mr. Haskins, you're really talking now about that everybody wants to see this building whole, that it's important to Tom, that your reputation, that you do care about your work, whether Kathy sees it that way or not. You do. You care about your work, and you want to see the building done well, back to what it needs to be, or in the shape that it needs to be safe and constructive, and also your reputation is obviously important to you as well. And so you're proposing kind of taking a look again at what needs to be done now in order to achieve that goal.
Right. Irrespective of fault or blame,
Yes.
it behooves both of us. It serves our interests on either side of the table to know precisely what it's going to take to move us from where the building is now to where the building needs to be. And I think we may need to discuss this on the basis of what we can do jointly, perhaps with our engineering experts, what we can do as far as getting an assessment done as to what is agreed, and maybe maybe between our two experts, maybe they can bring in a third mutually agreeable individual to give us what's the punch list for what needs to be done to take your building back to where you need it to be, and to where Tom believed that after the point in time that he repaired that leak on the roof in 2003, where he thought it was. So I think that might be something that perhaps we should explore.
And is that the way you feel too, Tom?
Sure, and the reason we're having this conversation in this way right now is that I think that we've gone all kinds of places, but I think that we definitely can agree on wanting to get to the next place. I think there's a lot to figure out as to, we have big disagreements as to, who should pay for what, but I'm totally comfortable with the idea of finding a third person, different expert, that we can both agree on, and take a good look at the whole thing. And then, as you said, look at it, the problem in terms of the building, we can figure out who pays for what. At this point, I don't, I'm not making any commitments around that.
So
It's really to say that I will work with you to get the building to where it needs to go. Now, it may very well be, and I just don't know. I mean,
we're dealing with something that's a bit too amorphous.
Yeah.
And at this point in time, I know there's been a lot of emotion, it's been fought out in the community to some degree, and we're fighting it out in court now. But I think the situation as far as what we can do about the building, if that problem is dealt with first, or at least we know what the problem is, I think it gives us the chance to potentially move forward on these other issues too.
Yes, it's nice to hear that one point of agreement we may have is it benefits both of us if the building meets whole. Your reputation
Sure,
is
absolutely.
restored,
Absolutely.
and the reputation of the business is restored.
Sure,
so I do
absolutely.
appreciate that. However, a lot of money has already been expended to repair the building already. So at some point, what we may have to talk about is if you're willing to take a look at that and see,
I have to say, I think it's premature to bring that, to necessarily approach that issue. Now, as far as what the responsibility for costs that have been made previously, whose responsibility that is, I don't think we can necessarily look towards that until we have a clear idea as to precisely what the current problem is, what's existent, and what's caused it.
Okay, you talked about a third expert. Let me ask you this. If we were to find another expert,
Right.
and if that expert were to show that there were some defects in the building design that has caused this problem, would you be willing to share in the expense?
Well, not if it's a design
Well-
question.
No, a construction, if there was defects in the construction. Because
Are you talking about the,
Wait a minute. Of course he'd be willing to share in the expense.
Well, we have
There's no way,
No.
I'm not, I appreciate,
Mr. Haskins
I appreciate
explained
where we're
that
getting
I'm
here,
a
but-
builder. I'm not an engineer, and I'm not an architect.
If the expert finds building defects that fell under your purview, would you be willing to look at that?
The question is whether the expert analysis finds fault that somehow relates to Tom's initial work, what responsibility he might be able to take with regard to that.
That is the
is
question.
that correct?
That
Full
is the
responsibility,
I-
I would assume, full
So what you're
responsibility.
talking about right now, and Kathy, I hear you saying full responsibility, is having this third expert take a look at the whole picture with the goal of restoring the building. Ms. Gill, you're talking about costs that have already been expended as a result of what needed to be repaired. Mr. Haskins, you're talking about taking a look at the whole picture and going forward as well. But what seems to be on the table right now is this third expert would give an analysis of that and give some recommendations as to what he or she thought caused the problem and what would be best going forward. Is that?
Yeah, I think that's true. Tom is someone who stands by his work. I think
Absolutely.
that he did do the building at a discount in the first instance. When the initial leak occurred in 2003, back at that point, he also did that without any charge. So Tom's shown a reputation of standing by his work. Heaven forbid we should find something that, the building is going to need to be leveled for some engineering problem that none of us are aware of, and starting from scratch. I don't think that we can really get into parsing out precisely what costs that we don't know are, where they belong.
I'm not
I
talking
think
about
that-
future costs. I'm talking about what's already been spent.
Well, as far as what's already been spent, I think we need to ascertain why they've been spent and what the cause was. I'm not going to say that we're not willing to discuss costs, even past costs necessarily, when we know something more about what that situation is. And I think that realistically, it may be an appropriate time to come back for a discussion such as this. Or it may be appropriate for you and I to have a discussion between ourselves. But, I think in the first instance, we should see about getting some solid information so that we have a knowledge base that we can move forward.
Well, I would agree with you, but I would not want us to get that solid information and then you say, well, we still don't want to take some responsibility for it.
And we've just spent extra time and extra costs. I'm
Well-
sure you're not looking to spend a bunch of extra costs either and
No.
not have this resolved
No,
in some
the thing
way.
is that, but I also do want, and this is what we're putting out, is to get someone we both know and trust, a different new person to look at the whole thing and be able to draw the line between the end of my warranty, which is all in my contract, which actually ended in 2007, and trying to ascertain what happened where, and to figure out, if there's anything that is wrong with what happened with the work within the normal warranty period. I do that with all my
So you
clients.
really want to
Someone
take a
clarify.
look, have another expert take a look at all of
Absolutely.
this to kind of parse
Because
some of
we
this
have-
out and get another
Absolutely,
opinion.
because the thing is that, this is a big part of our disagreement. This is a factual thing. Somebody can discover this.
Right.
So,
Counselor, you and I both know, if we can be candid here, we've hired experts to essentially, carry our viewpoint. If we want to discuss this, and we can make an agreement that we will use the impartial expert that we get at trial, either of us, for any purposes, we can bring in someone with the guidance of our two experts and see whether we can get a basis for working out some sort of arrangement or settlement here. It's an approach to consider, because if not, we can play scorched earth too.
So you're
but do we want to do that?
You're suggesting let's start here, not with any promises, not with
Right.
any commitments,
No
but
preconditions as
And
to
we
what
also-
warranties apply or don't
we-
apply. None of that stuff on the table. Just what's the status of the building
Let's
and what
see.
was the source of the status of the building.
so you're,
the warranty's there. That's something that's signed, sealed, delivered. You got the building with the warranty.
Yeah, but there's
So let's-
there's
let's
legal
not-
there's legal warranties that trump what's in your contract. So I suggest that we set aside those kinds of if at the end of this we got into a fight over when the warranty was, that would be a different fight than a question of what was the condition
That's,
of the
that's more of a fight over on our side.
That's more of a fight over on
that's
your
let
side.
them
That's
deal
right.
with
And
that.
so what I'm
But-
saying is we won't talk about that question now. That's a question over on their side of the table. What we'll talk about is trying to get an expert
so-
who both of us
Right.
trust.
So I'll get my expert,
And
your
you'll-
expert. You call yours and let them confer. And if they can agree on a third person whom they both respect, like Bob said, then we can both have access to the findings of this person, and present them to each other with each other, and we're gonna put both of our trust in it.
so both of your experts you're asking your
find-
experts to find you
Exactly.
somebody that you
No,
can agree on.
I would trust anybody, our guy.
And I just want to make clear that just as you're not making any commitment yet, neither are we. We still reserve our right to continue with the lawsuit. So
Sure.
we hope that this works. We're willing to explore it. I'll have to confer with my client.
But you know that my real reason for being here is this whole kind of cloud over me and my firm that's still out there even after this conversation. When you kind of reserve this right to pursue, it's not helping me
Well,
with
$1
my
million
reputation.
out of
Yeah,
our pockets
because-
is not
Isn't
helping
helping
us.
me. No, but the thing
We've
is that
already
when-
spent that money.
But but the thing is that the only thing I have out of this right now is that my reputation has been assaulted in this very, very small community. Anybody who's heard of these claims being put out, and frankly, I haven't responded to.
So
That's-
Tom, it sounds like you're saying that your motivation for being here is because you want to address this. Your reputation is out in the community. It's a cloud over you,
Yeah.
and the reason that you're here, you understand that the lawsuit is there. You have just as much motivation or
Absolutely.
intention to get this addressed
Absolutely.
as they do by
Absolutely.
keeping the lawsuit.
Right, but the thing is that
I have
but the
reputational
way
issues
to,
too.
the
We're
thing is,
not alone in that.
right, but the thing is that I wasn't the one who wrote letters to everybody I had ever
Right.
met.
When they
Okay.
went, well,
So-
it was to the parents.
Can
but
we?
still.
I mean, what's happening right now is this was a conversation that was making me feel comfortable. Okay, I was feeling like You had come in, you had said, I stand behind my work, something which I haven't heard you say in a long time.
Always did.
That you were coming in and saying, let's do something reasonable. And I'm kind of, but now it's moving over into, I was unfairly impugned in the community, where I feel like, frankly, that my reputation, that you have done tremendous damage to my reputation. So I'm thinking that maybe, since we were all kind of like relaxing a little bit there, we can just like not talk about who did what to whose reputation right at this moment.
As far as
and
that goes,
go someplace.
maybe we can back off on that to a degree as far as that discussion until we have the experts come in. Because I know the statements that were made in the letter that went out to the parents, you had a view at that point in time as to whose fault things were. Perhaps we might be able to approach this in a fashion with an independent individual, and perhaps your viewpoint might change in that regard.
Or he may discover that my viewpoint was correct.
perhaps
But we don't have to decide that in this room
We do
right
not.
now.
No.
We do not.
Okay.
But just so you know why I'm here. I mean, otherwise we could have just let the lawyers deal with it, right?
Well, and
So-
I'm here in much the same sense. Like you clearly have seen, I'm sure. My tremendous frustration has been an inability for you and me to try to work to some sort of reasonable thing that would preserve both of us in this community. Where I've been in a position where essentially I have felt like I am drowning. I'm losing all of my credibility. My business is tanking. And I'm not hearing from you. So I view this as very positive, that you're here, that you're talking about something that sounds like...
Let's see whether we can find a path through working with an independent expert that can potentially lead to some rehabilitation for everyone here.
We definitely appreciate that agreement to explore that. So maybe that can be a next step for us, and you and I can talk about, contact your office.
We'll probably need a continuance as far as the court suit to give us some time to do this. So.
And then you and I can talk about going forward, and we'll deal with the experts and go from there and set up a timetable.
So Ms. Gill, that sounds like it's a good next step that you and Mr. Haskins will make any motions or any court.
We'll take care of the arrangements.
You'll take
with
care of the
judge.
court.
Yeah,
Okay.
we can put a stay or for the time being, since we're trying to find a solution outside of court.
And that in the meantime, you'll explore with each of your experts another expert, asking them to choose somebody so that you can have that expert, the new expert or third expert, take a look at the whole situation and figure out where to go from there, and possibly another mediation session once you have some additional information by which to go on.
Can I just have a moment to talk to my attorney? I have an idea, but I don't want to... Just a second, 10 seconds?
Sure, you want to step out of the room?
Yeah, can we, or just can I whisper in her ear even?
Oh, yeah.
It's up to you how you...
I can whisper in your ear, if that's okay with you.
Okay.
Well,
All right.
I'll whisper over you.
So motion might not a motion, but some kind of a stay
Just to get the court to
wait.
delay things
Delay.
for a while.
Okay.
Always sort this issue out.
Because we're still preserving our rights for litigation. Should we decide to go after
After all that chit chat, I guess really what it amounted to, Tom, I just want to come back and just sort of say to you, because I'm hoping that this will end up being a situation in which we can work together to sort of solidify our reputations and so on in the community, that this becomes something that is a foundation for us to work amicably through difficulties we have. And I am very hopeful that at the end of this, we can get rid of these guys eventually, and we don't have to go for it. And I just wanted to say that to you. I appreciate your coming here.
I appreciate your saying that. And frankly, Mr. Haskins is a great lawyer, but I'd rather not spend my money.
On
No offense taken.
Agreed. Well, thank you for saying what you did, because it's been a tough day. I mean, I heard a lot today, so that means a lot for you to put yourself out there as you did. I really appreciate that.
So in terms of going forward, should I check back in with you in a few weeks? Do one of you want to call me? How would you like to?
Probably, we should be able to speak to our experts, get things together within the next week or two.
Yes.
And then, hopefully get someone in within the course of a month. So if you want to check in like 2 weeks to 4 weeks and see how we're doing at that stage, does that sound
That'd be
reasonable?
fine. That'd be
Okay.
fine.
Okay, I can do
we'll
that.
keep in touch with you as well.
Okay. And so it looks like we could be looking at a month and a half to 2 months before the next session.
Yes.
If you're going
Yeah,
to.
that would
Yes,
sound
we want to
about
give
right.
this a fair chance.
Sure.
Right.
See if we can find somebody we agree on.
Right,
Okay.
See what information we can gather.
Okay. Is there anything else at all that you'd like to touch on or say at this point? It sounds like you're all in agreement in terms of where you are right now and concluding the mediation today. Is there anything else that you think needs to be
No, I
addressed?
don't think so. I think we're clear.
Yeah.
We're clear, and I do think a lot of the issues, even though there was some difficulty, but we sorted through a lot of concerns. The concerns are out there now, and I think this is a productive suggestion. We'll explore it.
Yeah,
Okay.
we can see whether we can reach some resolution at some
Yes.
point going forward with the suit.
Okay.
Okay. Very good. Well, thank you very much for all of your time today.
Thank you.
I
Thank
appreciate
you
that.
for your efforts.
Thank you.
We appreciate it.
Thank you. Okay, and we'll be in touch.
Great. Thank you.
Great.